On the slopes of Diamond Head, this is Kapiolani Community College. Kulia ika nu'u, strive for the highest.
Aloha, this is Ben Carroll. I'd like to welcome you to BLAW200, Legal Environment of Business. Last time we had some fun with intellectual property, trademark, copyright, patents. This time we're going to get into one of the major areas of business law, and that is contract law. So, as always, let's start out with a review of what we covered last time. Okay, we were talking about intellectual property. What do we mean by intellectual property, and why are the creations protected by law? Okay, intellectual property is typically found to mean patents, trademarks, and copyright. Sometimes people would add trade secrets, and sometimes they'll even talk a little bit about unfair competition. But the three main ones are patents, trademarks, and copyright. And why do we protect what we call intellectual property? Well, as you recall, two of these were included in the Constitution, and the idea was to promote the public good, to make new and useful inventions available to the public, and to advance progress. So that's certainly a major purpose of intellectual property. But more and more it's been turning also to protecting the individual rights. So we do have that balance, and there are, as we talked about, some questions about whether the balance may be leaning a little more towards the individual as opposed to the promotion of the public good. Okay, how does a copyright come into existence, and do we have to register it? You may recall that copyright comes into existence simply by putting your creation, your artistic or literary creation, into fixed form. So as soon as you write it down, as soon as you record it, it is in fact copyrighted. You have rights attached to that. Now, both the common law and our copyright statute have incorporated that, so that remains the case, but they've added some other things like notice and registration. Okay, those are optional. The notice is simply putting a little C in a circle or copyright, date, name of author on your material, and you can do that at any time, although, again, you don't have to. Registration is formally registering it with the Copyright Office, and that provides a lot of benefits, including putting the public on notice, and also it's a prerequisite. You need to do that in order to file an infringement suit and to get the statutory damages. And since it is cheap and it is reasonably easy to do, that may be worth your while. This, again, is quite different from the patent process. Okay, what do we mean when we say something's in the public domain, and what types of materials might be considered to be in the public domain? Again, public domain implies public ownership, so these are materials that are not protected by copyright, and anyone can use them in any way. So how do they get there? Well, some things are simply put into the public domain by their nature, and that includes most of our U.S. government documents. So I guess in essence we've already paid for those with our taxes, but most of that material produced by the government is public domain, so you can use that freely. How else might it end up in public domain? Well, the copyright or other protection can expire. Okay, so in that case it now becomes public domain. It used to be copyright protected, now it is not. Or somebody can simply put something in the public domain and say, I do not wish to exercise my copyright rights, and so I'm putting this into public domain. So if it ends up in public domain and you're sure that that's the case, you may use that freely for any purposes. Okay, how about the fair use exception, and more particularly just the things we find on the internet, pictures, etc., are those available for our use? Okay, now fair use differs from public domain. So fair use is something that is actually still subject to copyright. So we're talking about a use of copyrighted material, and it's a use that the law allows even without the permission of the copyright holder. So the copyright holder doesn't need to agree to this. If they agreed to your use, they would be issuing you a license, different process. But this is use you can do without their permission. And so why do we have that? What does that look like? Well, these are specified uses for what are considered to be publicly desirable purposes. So that would include teaching people, that would include using it in criticism, including satire, using it in news articles, using it for research. So it's been determined these are desirable purposes, and so we're going to allow those uses. Now the uses are going to be restricted or limited, so there are limits on how much you can use. You can't simply grab a whole chapter or a whole book and put it online. There are limitations on what the effect is on the other person. So if you are putting things up and that's detracting from their income, that's going to be seriously looked at as well. So remember, we looked at the criteria to determine, is this more likely to be fair use, having a public purpose to some extent, or is it damaging to the copyright holder, in which case we would be less likely to find fair use. Okay, now a lot of stuff on the internet, a lot of people thinking that if it's there I can use it. Remember, a lot of that is protected by copyright, and so simply because you can easily take that down does not mean you're not violating a copyright. Okay. What's the purpose of trademark protection, and what kind of things can serve as a trademark or a service mark? Okay. You recall this is any number of symbols, names, colors, etc. that can be used as a trade or service mark. And what do we mean by a trade or service mark? This is a mark that will identify the origin, in other words, who produced this, and that was its original development, was to ensure quality and to make sure that we knew who produced it. Okay. There are now some additional benefits, and that's simply the goodwill or reputation that attaches. So some of these logos and some of these trademarks are worth a whole lot. And when we talk about franchising, when we talk about operating a Burger King or a McDonald's or a franchise, you can see how much you would be paying for this goodwill that's embodied in the particular logo or trademark. Okay. Now remember, not only can it be a picture, and those pictures kind of immediately bring something to mind, it can also be names, anywhere from a descriptive name to something very fanciful that has no particular meaning other than the meaning when we start to know that it means this particular product. It includes color, it includes smell, so a whole lot of different things can be incorporated into distinguishing this particular product and making it instantly recognizable to us. Okay. How has the internet affected intellectual property, and what are some of the IP concerns, including international concerns with intellectual property? Well, as we've already hinted at, the internet makes it very easy to copy and to obtain materials, so that people have gotten to where they think it's just routine to be able to copy something. So very little effort involved. And there's also kind of a movement of thought that sharing is good. We are interested in the public good, and so why should somebody be able to restrict this? Why shouldn't everybody have access to information? So we're becoming an information age, but people are feeling kind of an entitlement to that. So there are some disputes about what should or should not be protected, how long it should be protected, who should be subject to penalty or attack because of using it, that sort of thing. And again, finally, we just briefly touched on some of the international concerns. And particularly among developing countries, there's some concerns that having things patented, having them protected, is keeping us back, holding us back. So some of the international agreements actually are requiring licensing of certain drugs. So the certain drugs that are necessary for the health and well-being in countries, you're not allowed to only be the only one selling. You are forced to license that to different countries. So there's some developments there. Again, we've talked about those are on the La Lima site if that's an area of particular interest to you. Okay, well, as I said, today we're going to get into the kind of the real nuts and bolts of business law, and we're going to talk about contracts. And you recall that contracts are a major area along with torts. And so what's the distinction? Well, you recall torts are things that happen to people based on duty. A lot of those associations are involuntary. In other words, somebody injures you. Whereas contracts, we're talking about the voluntary agreements, the associations. And so we kind of shorthanded those by calling those the deals. Okay, so today our agenda is going to be to kind of get the idea of the basic elements of contracts. We're going to talk about offer and acceptance, and there's going to be some specific terms or doctrines that we talk about, like the mirror image rule or the meeting of minds. And then we'll talk about the requirements, that we have an agreement between people, that we have consideration, that they have the capacity or ability to understand they're in a contract, and legality. So this will be kind of our introduction to this large area. Okay, so what are the goals of contract law? Well, should be obvious as we're trying to organize our agreements with people. We want there to be rules for knowing when we have a contract and how to enforce it. We want to be able to penalize the people that breached it. And you recall we used the term breach when we were talking about breaching a duty, so it means failure in. So we want to know what to do if somebody fails to do what they said they would do. We want to protect the people who do what they say they will do, so they fulfill their promises or they perform. And of course, bottom line is we want this to happen without having to go to court, because you recall court is a lengthy process, expensive process, a lot of downside. We want our business to go rolling along without the intervention of always having to go to court. So we establish the rules by which we know when we have a contract and what our obligations are. Okay, so getting more down to the nitty-gritty, what is a contract? So let's look at a possible example here. You can see someone appears to be ready to trim some trees. So let's say person A says to the other, I will trim your trees for $100. Person B replies, okay. So is this sufficient to establish a contract? Do we need something else? So let's think about that a little while. So very simple discussion or exchange here. One person says, I will trim your trees for $100. Other person says, okay. So what do you think? Do we have a contract? Well, some of the things you might be thinking about is, a lot of times people say, does this need to be in writing? Is it enough? Can you just say that? Is that going to be enforceable? Because we want it to be enforceable if it doesn't work. Is that enough to be enforceable? I will trim your trees. Well, does that include all the trees? Does that include the shrubbery, bushes, every kind of tree, just the palm tree? So we've got a banana tree. What's included? Is that specific enough? Of course, it may make a difference if we're standing there and gesturing or something else that might be give us information about that. But there could be some questions what we're talking about with the trees. Also, what do we mean by trimming? Is that simply taking the coconuts down? Is it getting this something that's hanging over something else, cleaning out the rubbish? What do we mean by the trimming? Are we clear that we understand what each other mean? And how about, again, person's in front of us, maybe we're in our yard, they've come up to us, I'll trim your trees. You look over, there's a pickup truck, there's a bunch of folks in the back, including some pretty young kids. Well, do you mean you are going to do it, or do you mean the kids? Because I'm not sure I want the kids there, et cetera, et cetera. Okay? So, a lot of questions we may have. Again, if the truck's there and the guy's pulling out the equipment, you think, okay, you're going to do it right now? Well, that's great. Okay. So, a lot of questions we might have as to whether or not we have done enough to have a contract here. So, maybe yes, maybe no, but those are the kind of questions we might look at. So maybe we have a contract. I'll trim your trees for $100, okay. But we need to look at and see if we've got the right elements, if it's something that we think that the court's going to be able to enforce. Okay, so contract is, in fact, a binding legal agreement. So as we talked about, we're interested in whether or not we can be bound, whether or not it can be enforced. Other descriptions of contracts talk about it's an exchange of promises, and these are enforceable promises. But again, we'll talk a little more, but some promises can't be enforced. Okay. Now, needs to be recognizable at law. That's what we mean by enforceable contract. If you think back, this is similar to when we said we wanted actionable negligence. In other words, we want negligence that we can take to court and receive our compensation for. With a contract, we want an enforceable contract, one that, for whatever reason, we would be able to have the court behind us if somebody did not do what they said they would do. Okay, and again, this is voluntary. This is an agreement. Okay, so the typical elements of a contract, and these are fairly standard. So the first four of these: offer, acceptance, consideration, capacity, legality, you'll see on almost any contract list. So these are kind of our common law elements. And I've added a couple more at the bottom here: required form and genuine assent. And sometimes people will characterize these as contract elements, but on other instances they'll say, well, actually these are defenses or that we might use. But they are very closely related. So again, your question of whether or not we needed to have this particular agreement in writing, there will be some law that tells us some agreements do need to be in writing. They need to be in a certain form. And genuine assent, you may think, goes back to whether or not we have an offer and acceptance, whether or not we have an agreement. But again, we'll be talking about that as well. So we're going to look at each of these elements. We're going to look at the offer and acceptance, which is actually the let's make a deal part of it. We're going to look at consideration, and that's the exchange. So if you look back, you can see what the exchange was in our tree trimming example, what was being traded, exchanged between the folks. Capacity simply means that we have the ability to understand and the intention to enter into a contract. And legality means that the purpose is not illegal, violating either a statute or public policy. So again, those first four are kind of the guts of contract law, and we'll take a look at each of those. Okay, so offer and acceptance. This is the process by which we have a contract. So there needs to be an offer on one side and then an acceptance on the other. And they need to show an intent to enter into an agreement. We call this the objective theory. In other words, we're not looking at intent, as we sometimes do in criminal law, as being subjectively exactly what that particular person was thinking at that time. We're looking at it in an objective sense. So we're looking back to our reasonable person. Would a reasonable person understand from the words, from the circumstances, from the actions that the folks intended to enter into a contract, that they intended to make an offer and an acceptance? So we've already looked at the possibility of not understanding terms and having some uncertainty or ambiguity about our terms. And you may recall this goes back even to looking at our statutes when we had beach trash, where we want to be sure that we're using words in the same way so that we are in fact coming to an agreement because we mean the same thing with our language. And of course the offer needs to be communicated. It needs to be transmitted to a person in order for them to accept it. Okay, now there's some things that we might look like a little bit like offers, but they're not offers. So a lot of times we'll have advertisements and they will say, come on down, buy new car for $88. Okay. Is that an offer? Well, in most instances, it's considered that the newspaper publication is not an offer. It's an offer to offer, so to speak. So it's an invitation to come down. But there are certain advertisements that may not, and that would be, for example, a reward. So if you say, if you bring back my fine dog, I will give you a reward of $1,000. If you take the dog back, that has been an offer to you, and you are accepting it by the action of taking the dog back. So that could form a contract. But your normal sales product kind of thing is not considered to be generally an offer. Now, if it's very specific, can be accepted in a certain way, perhaps. Okay. Now, an auction, you might think that the auctioneer is making an offer and the bidder is accepting, but it's the opposite way, actually. The auctioneer is offering to accept bids. The bid is the offer, and then the auctioneer accepts it with the gavel. So that's a little bit different. And there are a number of other things that are kind of preliminary, and we don't consider those to be contracts. So, for example, if you are saying in the future, I think I will probably want to sell my car for $750, somebody can't say, I'll take it. That you have not created a contract. You're expressing something in the future or an opinion, and that's not a true offer. There can be agreements to agree. Okay, let's get together and hammer this out, and what I'm thinking now is we're going to do this and this and this. That could be either an agreement to agree or a preliminary negotiation. So again, we're going to look at the reasonable standard. Would people think that this is actually an offer that can be accepted, or is this something more preliminary? Okay, we refer to meeting of the minds, and this is just a term of art we use, and it's also called mutual assent. And we will be talking about assent. You recall that was one down on our list of elements. And there are various things that may damage assent or may show that assent isn't there. So that could be, for example, fraud, mutual mistake, duress, that sort of thing. And we'll be talking about that in another session. But we're essentially looking to have a common understanding that that we have in fact agreed on terms. So an example might be if we're talking about selling a Mustang. Well, we want to be sure we're talking about the same thing. One person may think they're getting a car, the other may think they're selling a horse. There are things of this nature. For example, I'd like to buy your stock. Are we talking to a rancher about cattle, or is he talking about shares of corporation shares in his ranching company? So again, those are just kind of simplistic examples of where we might not have had a meeting of the minds. We're not really talking about the same thing. And we're talking about using the same language, so you can imagine in foreign transactions, got to have another level here. Okay, this brings us to the issue of definiteness. Okay, are we using terms, is there enough certainty that we know that we have an agreement, that we've had an offer and acceptance? So there's some things that need to be definite. These are kind of obvious. Okay, one of them is the identity of the parties. Now you might think, how can you have a question about the identity of the parties? Well, it may be that you're contracting with someone and their employees are going to do it, and it may make a difference to you who exactly is going to do it. Okay, when we're dealing on the internet, we may not know who's on the other side. So there's certainly some issues. We want to be sure we know who it is that's contracting, who we are making the deal with. Okay, we want to know about the subject matter. Okay, so again, in the tree trimming, when we say we're trimming the trees, do we know what trimming in trees mean? Or, are you going to be lopping off the tops of everything, or are you just going to be cleaning up around the edges, whatever? So we want to be sure that we're real clear what our subject matter is. Okay. Want to be clear about the price. And again, price, we'll look at this in a minute. We call that consideration, so that's the value. But we want to be sure that we are agreed on what the value is. Usually this is not so much a problem when we're dealing with money or goods, but as we'll see, consideration can be other kinds of value. So there may be some ambiguity about exactly what's being exchanged. Certainly if we're dealing internationally, we might want to put U.S. dollars so we don't get paid in Hong Kong dollars, which are, $7 or $8 to $1. So again, we want to be sure that we know what's being exchanged. We want to be sure we're clear on when it's going to be performed. Remember the tree trimming, if they're right there, they're about ready to unload the equipment. We're understanding from context that's going to happen right now. But if we don't put a time in there, a week later we're saying, hey, I want to sue these guys. They didn't perform. Well, when were they supposed to perform? Well, I was thinking they were going to perform right away, but you haven't made that clear. So we need these to be definite so that the court is comfortable that there was an agreement and we know how and when and how it can be enforced. Okay. Now, we're talking common law concepts. Later on, we'll be talking about some specific provisions of the Uniform Commercial Code, and the sales under Uniform Commercial Code may have some differences, so just keep that in mind. But these requirements of being definite, this is in our common law contracts that we would normally enter into. Okay, now once we've made an offer, what can happen to an offer? How is it accepted, and what can happen to it other than acceptance? Okay, I enjoy this idea of an offer dying. So And I got this from, I think Professor Blake and Mercer first came up with this, but it may be useful to you. It's kind of fun, but let's take a look at that. So how does an offer die figuratively? How does it go away? Well, one is lapse of time. So if there's a time in the offer, or the offer is only said is stated to be only open for a certain time, and then the time passes, then it dies. So we can call that natural causes. Okay, what else can happen? Well, we can withdraw or revoke the offer. Same thing. So the person that makes the offer takes the offer back. Says, "I've changed my mind. I'm not going to do that." So we might think of this as suicide. In other words, the offer dies with the person that made it. Okay. Now you may reject the offer. The other side may say, "I won't do it for $100. I'm not going to do that." Okay. So that the author's been killed. Okay. So it's been rejected, and that's murder, perhaps. The offer's been murdered by the other side. Okay. Now, if you make a counteroffer, in other words, you say, "I won't do it for 100, I'll do it for 80, that's killed the $100 offer too. And we'll talk about that in a minute. Okay. And sometimes the offer will not be, the operation of law will mean that the offer can't be accepted. So the law changes or something makes the offer not valid, and we could look at that as being execution of the offer. Okay, so those may help, but they're kind of fun. There are some literal ways that the offer can die as well, and those are much more, I think, understandable. But either the person that's making the offeror, can die or become incompetent, or the person that's meant to receive the offer, the offeree, can die or become incompetent. So the offer would then die, so to speak. Or the subject matter of the offer is destroyed. So you're going to sell your house burns down. Nothing left to be part of the contract. So in that instance, the subject matter has died or been destroyed. Okay, so these are the ways that an offer can go away or be disposed of without having an acceptance. So those are all possibilities. Okay, now how do we accept an offer? Okay. To accept an offer, it needs to be unconditional. In other words, you are accepting exactly what's being offered. So you can't say yes, but. So there's no buts in your unconditional acceptance. You need to communicate your acceptance. So you need to let them know, "I do accept." And you can do that in any fashion that's a normal way of communicating. So unless the offer says you can only accept it in writing or you can only accept it in a certain way, then your acceptance could be through any normal communication. So telephone, fax, email, letter, snail mail, whatever, would be a normal way of accepting, unless it's noted that you have to accept a certain way. Normally your acceptance is valid when it gets received, but we do have what's called the mailbox rule, which means if you send your acceptance by mail, then upon the posting, it's effective. Okay, so you may have instances where someone is sending you a revocation of the offer, telling you it's revoked, but you have already put your acceptance in the mail. So in the mailbox rule, your acceptance would trump their revocation. Okay. Some courts are figuring whether or not email is closer to mail or closer to needs to have delivery, and there's some different rules on that. Okay, the mirror image rule means that you need to accept the offer exactly as offered. So you have to have a mirror image. If you say, "I will trim your trees for $100, then you accept it. Okay means I will pay you $100 to trim my trees. If, on the other hand, you would say, I accept your offer, but I need $150, or I accept your offer, but I will only pay you $80. That's not really an acceptance, because we have the mirror image rule in common law, which means you can only accept what was offered. If you try and change it or modify it, then you have in fact rejected it, and now you're making a counteroffer. So if you say, "Okay, but I need a different amount," what you're doing is you are now offering to do it for a different amount, and the other side would be the side that accepts you. accepts it or not and forms a contract. Okay, again, this is the common law rule, and as we noted earlier, in sales under the Uniform Commercial Code, there may be some differences when merchants are dealing with each other. Merchants are considered experienced experts, so to speak, so we may change the rules a little bit, and we'll talk about that when we get to Uniform Commercial Code. Okay, so let's look and see if we have a deal. So on day one, the owner faxes tree trimmer B and says, I'd like you to trim my trees I'll offer you $100 and you have 10 days to accept this. Okay, so tree trimmer B gets the emails back, or gets the fax, emails back. That seems a little low. Can you pay $150? Okay, gets no reply. Subsequently, another tree trimmer gets wind of this going on, and so this tree trimmer goes back to owner and says, I'll do the job for $80. Okay, so undercutting, putting in an offer. First tree trimmer, B, hears about this undercut and right away calls up owner A saying, I will do the job for $100. Okay, so what's happened here? Do we have a deal? Who's got a deal? Let's make a deal. So what did we have? Let's look at this kind of in order. We had A saying, I will pay you $100 to trim my trees. Okay, so that's the offer. And then what does B do? Well, B says, seems a little low. Would you pay $150? Okay. Now, this is the crux of the matter. This is it. What are they doing with that transmission? Okay, so you remember, if they are making a counteroffer, that would be a rejection. Okay, so the offer would be gone. But is that a counteroffer, or is that something else? Okay, so would you be willing to pay? Is that rejecting the $100, or is that maybe an inquiry? Is that a negotiation? What is that? And this is really the crux of the matter. So let's think about that. That's important, what that particular transmission is. Okay, and what do they get back? They get back nothing. The owner doesn't say a thing. Okay. Then what happens? Well, third party, somebody completely different, finds out this is going on. And so they approach the owner and they say to the owner, I'll do it and I'll do it cheaper. Okay. So what's that? Well, that's an offer by C. Okay. Not part of what's going on with B, but that's an offer by C. Okay. And then when B hears this, right away they accept the offer. Okay, so they call and they say, I'll do it. I accept your offer. So what do you think? Do we have a contract here or not? Okay, again, let's just look at a couple of things. How long did they have to accept the offer? They had 10 days. So the provision was set that you have 10 days. So anytime within 10 days, you can accept that offer. We are holding that open for you. So during that time, could the owner A decide, hey, C's going to do it cheaper, I'll go with C? Now, there would be a problem with that because they've said you have until 10 days to accept. So until that 10th day, as long as the offer's out there, they would not be able to contract with another person without being liable for two contracts. So if they had said to C, oh good, we'll do for $80, and then B accepts, now they got two people doing the same job. Okay, so they've said that they'll keep that offer open. Does it make any difference whether it was emails or faxes or telephone calls? Nothing in this indicates that they had to accept it or deal with each other in a certain way. The offer could have said, I'm sending this to you by certified mail, you need to accept by certified mail. Or it could have specified, and that might have affected it. Okay, but as I said, when we look at this, it makes a difference what that transmission back from B is. If that was a counteroffer, remember, a counteroffer is a rejection and an offer. But in this particular instance, that's probably not going to be a counteroffer. That's simply an inquiry. Would you be willing? And by their silence indicated they weren't. So would you be willing? That hasn't killed the offer, so that hasn't rejected the offer. So the offer is still open till the end of the 10 days. And when did the person finally say, I'll accept, day 9. So they are within the period in which they could accept. Okay, so just wanted to give you kind of an illustration that we do need to look at what's going on. We need to look at the circumstances. We can look at our rules about, are the requirements that it be done a certain way? Have we stated in the offer that it's open for a certain period of time? That sort of thing, in order to analyze, have we got a meeting of the minds? Have we got an offer and acceptance that's going to be effective? Okay, consideration we already mentioned very briefly, and consideration is really an exchange of value. So in the normal cases, money for goods, these transactions happen all the time. You're very familiar with that. So with money, goods, and services, that's familiar to us. But what we might look at that's a little different is there can be exchange of value that is not tangible. In other words, it's not money, goods, or services. It's something else. So we have legal rights, and our rights are worth something as well. So we may give up a legal right, or we may incur what's called a detriment. So a benefit or a detriment can also be consideration. Okay, if we already have a duty to do something, and we offer to do it, what are we offering? Is that any value? No. If we already have to do it, we're not giving anything new. We're not giving any value. And the same with a past occurrence. So if somebody, for example, saves our life, and then we say, that was good, I'll pay you some money, we may be making a promise, but it's not consideration because we've already received that value. We're not bargaining, we're not having an exchange. So let's look at those and see if we can nail them down, make a little more sense of them. So again, the one we've already looked at is kind of clear what the exchange is. So let's trim the trees. Party A promises to perform service. Party B promises to pay for the service. So the consideration on one side is the service. Could also be goods, products. And the other side is money. And this is very, very typical. So you're actually involved in a contract every time you go and buy something. Okay, so you don't sign any paperwork, but you have an agreed exchange, and there's consideration there. Okay. So we also said, in additional to goods and services and money, these tangible things, that we can be exchanging something else as long as it's value. So if we look at the next one, we can talk about if we're settling a lawsuit. So on one side, we are promising to pay money in a settlement, and on the other side, we are giving up what? We're giving up our right to sue. So one side is buying their damages, and the other side is buying the protection from being sued for what they've done. Okay. Now, you'll hear some terms, accord and satisfaction, and this means if you settle a case, the accord may be the agreement, and the satisfaction is the payment of that amount. And we've previously talked also about settling cases and using the release. So the release is certainly a contract in this sense, where the release is releasing the liability on one side for money coming the other way. So again, money coming one direction, but the consideration on the other side is giving up a legal right. And there's a famous case that's used as an example many times. For example, young person going off to college, and we'll assume they're of a legal age, and so a rich uncle or a parent says, if you will refrain from smoking, drinking, and partying all night, we'll pay you a set amount of money, $1,000, or we'll pay your tuition, or something of that nature. Okay, so is that an enforceable contract? I will pay you not to smoke and drink, etc. Well, we'll talk about legality in a minute, but for the purposes of this, let's assume that the person is of age where it is legal for them to smoke or drink. And so they are giving up a legal right, or they're incurring a detriment. So is that worth money? Is that consideration? Well, it certainly may be worth money to the other side, and so that may be an enforceable contract. One side's giving up something they have a right to do. The other side is paying for that. So we have consideration both directions. Okay. What about the instance where we've got a contract to trim the trees and the person doesn't do it? But they say, well, if you give me another $50, I'll go ahead and do what I said I would already do. Okay, is this going to be consideration? This is not exchanging value because they already have a duty. They have a pre-existing duty for something they've already been paid for. So they're not giving you anything new. There's no exchange for this new contract. You have the rights to enforce your old contract. So even if you agreed and then you only paid the original amount, you would be protected because there was no consideration for the new amount of money. Okay, and finally, similar to this pre-existing duty, what if you call the fire department, your house is on fire, and they come and the firefighters say, well, we'll put out the fire for $1,000, okay? You may be quite willing to pay that, but is there an exchange going on here? No, they already have a duty to do that. So you don't have to, if they have a duty, then they're not giving you anything. They already have to do that. There's no exchange on their side. So we don't have consideration here. Okay, we want to look at capacity. So capacity is a legal term, and you're probably more familiar with a similar, not quite equivalent term, medical term, competency. So we're talking about a person's ability to understand what's going on, to understand that they are in a contract and what the consequences of being in the contract are. So we want to be sure that, although it looks like there's an agreement, they have the capacity to be involved in an agreement. So there are several things that impact this. So we say infancy or minority, in other words, age. We talk about incompetence, so the mental ability, and we can talk about intoxication. So if you are under the influence such that you don't know what you are doing, then you may not have the capacity to enter into a legal contract. And we talk about these as being voidable. So that means that the court will look at it, and if they find this is correct, they will make a determination that the contract is not valid. But they have to look at it. So it's something that has to be proven. We have to show that these particular characteristics have in fact changed the ability, have negated the ability to understand what's going on. So we have to show these, and that makes this a voidable contract. We'll talk about void, which means no force and effect. But again, these are voidable. We have to show that these have affected it. Okay, so if we look at minority, a lot of people say or think that minors cannot enter into contracts, but actually they can enter into contracts. Unless, of course, it's a contract that violates a statute. For example, they can't contract to buy alcohol or cigarettes, but they can enter into other contracts like an adult. So why do we think that they can't? Well, most people will not contract with minors very frequently, and that's because these are voidable, as we said. So it's generally the adult on the other side that is not willing to contract, even though legally they could contract with a minor. The reason is that minors can avoid or disaffirm the contracts, and that's what we mean by voidable. So in many instances, a minor can get out of a contract they've signed. But just because the minor can get out, the other side cannot. So the fact that a minor can disaffirm or get out of a contract, it's not equal on the other side. The adult can't get out just because they've dealt with a minor. And again, this has come about because we're trying to protect minors from being taken advantage of. Generally, if a minor gets out of a contract, they would need to return the consideration or return the car or the computer or whatever they had obtained. But in most instances, they would only have to return it in the condition it's in. So even if it was worn out, broken, etc., they would simply have to return it, but not make up any difference in value. Because again, we're trying to protect the minors from being taken advantage of. Okay. Now, certain contracts a minor would not be able to avoid. So there are certain exceptions in the statutes, in the law, and we've said minors cannot get out of these types of contracts, even though in general they're voidable. These are not by statute. So, for example, if somebody enlists in the military, we're not going to let them get out. If somebody gets married or has child support agreements, they're not going to be able to get out of those because of public policy reasons. Okay. Now, the other thing is going to be necessities. So if it's food, shelter, clothing, if a minor gets these, then they're not going to be able to get out of paying for those. And the reason is we want to encourage, if a minor doesn't have any other way of getting the necessities of life, we want to be sure that people would be willing to contract with them to provide that. Because again, we said most people aren't going to want to deal with a minor, since a minor can get out of paying and not have to return things, but we want to encourage people to provide necessities, and so we make those non-voidable. We make those an exception. And in certain instances, misrepresenting your age will mean that you can't get out of a contract. And this varies very much from state to state, and it's also dependent on what kind of contract you're talking about. And actually how old you are. If you're 17 or so, that's a different matter as well. And there's material on the website about this age misrepresentation area. Okay, a couple of other rules about dealing with minors. One is called ratification, and this means after the fact confirming or agreeing to it. So once a minor reaches the age of majority, then they can ratify a contract, and they can do that either by signing something additional or simply by continuing to act as if the contract is in effect. So that would, in effect, ratify. Okay. And just a brief note about parental liability. So you remember we talked a little bit about parental liability in torts, and parents are responsible for their children, a lot of the action that the children do in the tort area. They're not so in the contract area. So even though parents are required to provide necessities by law for their children, and they could be on the hook for those necessities, with respect to other types of voluntary contracts, a parent is not liable for what the child's entered into on their own. So that's why you will see if somebody is contracting with a child, they're going to want a parent to co-sign, because the co-sign puts the parent into the contract. If the parent doesn't co-sign, they're not in the contract generally. So that would be just between the minor and the provider. And again, that's a voidable contract that could be avoided by the minor. Okay, so let's look at the competency issue. And of course, in one sense, we consider children to be incompetent, but we're talking here about a competent adult. So this concerns the mental ability, and this can be as a result of various things: brain damage, senility, mental illness. So these are various ways that the person might not have the capability to understand what was going on. So if the court determines that a person does not understand they're entering into a contract, or doesn't understand the nature, purpose, or consequences of entering into the contract, then the contract is voidable. Okay. Now they're looking specifically at the person's ability to understand the contract, not that they have other idiosyncrasies or mental lapses or something of that kind. So it's just like when we're looking at a will to see, did they understand what they were doing there? Not do they wear funny hats most of the time or do something different. So we are talking about their ability specifically to understand that they're entering into a contract. So if we are able to show that they are not, then this would be voidable, and then the person could get out of because they did not understand they were getting into. Okay. Now, it's a little bit different if the person has already been adjudicated. In other words, the person has already been looked at by the court. So in certain instances, a court will be asked to determine whether somebody is able to handle their own affairs. And so you might be appointed a guardian or a conservator for someone who's not able to do things for themselves. And if that's the case, if there's been a court ruling already that this person is not able to handle things, does not understand, then we don't need to look at that again. It's already been decided. And so a contract under these circumstances would be a void contract, not voidable. So it's void because the determination has previously been made, and the appointment of a guardian would indicate that. So I used to handle cases of this type as a guardian and trustee, and we had an instance where a bank actually gave a credit card to one of our clients, and he went around buying things. Very generous person, bought things for all the other homeless folks and that sort of thing. And of course, this was not enforceable against him because, as guardian, we were the only people that were able to contract on his behalf. And obviously, we're unaware that this was going on, but that was void. Okay, because the court had already appointed a guardian and determined this person is not capable of entering into agreements. So again, although usually with a voidable contract we have to look at the circumstances and decide should it be voided. If the court's already looked at the circumstances, that is void. Okay, intoxication. So it's possible that we will be under the influence of drugs, alcohol, etc., and will not understand what we're getting into. Okay, so we don't understand the consequences either that we're entering into an agreement or what the consequences are. And when this is applied, it can be applied, in many states, it's applied even if the intoxication is voluntary. So you went on a bender on purpose. Okay. Now, this does not mean that every deal that's done over a couple beers or a bottle of wine is voidable, okay? Because again, this is an instance where the voidable contracts, the court will look at the circumstances and need to have proven that the person did not understand what they were doing. And just as a practical matter, this one is not very often used. The court very, very rarely will allow people out based on intoxication. And most of the time, it's where someone else has caused a person to be intoxicated specifically to take advantage. So we'll look at this again when we look at genuine assent and the possible defenses against this, such as duress or undue influence, misrepresentation, that sort of thing. And the court will generally handle it in that fashion. Okay, legality. This, I think, is the easiest of the elements of the contract. So the court will not enforce something that's illegal. So interestingly, when we look at the movies and they talk about putting out a contract on somebody to kill someone, not going to be enforceable there, okay? Not legal. There have been instances where people have gone to court and they've indicated that they had a marijuana sale go bad, so the other person didn't pay them for the marijuana. So you can imagine what happens in these cases. They do not win that case, and generally the court will invite them to visit with the police or prosecutor afterwards, because this is illegal. Okay, so there are a number of things that will be illegal because of statute. Okay, so we have laws against what we call usury. Okay, usury is when we're charging too much interest. Okay, many states will have laws against gambling, so this is illegal. Okay, there can be laws that require you to be licensed in order to enter into contracts or to charge money. Okay, and finally, some states have what we call blue laws. And we don't have them in Hawaii, but they mean you can't sell certain things other than necessities on Sundays. And so those are all statutorily illegal. There's a number of others that sometimes are statutory, but sometimes are more public policy. And so those would be things like discrimination, restraining trade and monopolies that we'll talk about, whether something is unconscionable or exculpatory, that sort of thing. Okay, so in addition to certain activities, here we were talking about the provision. So an unconscionable contract is one that the court thinks is so unfair, it simply won't enforce it, or it won't enforce part of it. And exculpatory clauses are clauses where somebody is trying to get out of liability. So, for example, you may have a ticket that you get when you park your car, and on the back it essentially says, "We're not liable for anything." And of course, that's bogus. If they do something negligent, yes, they are liable for that. And they'll put it on the ticket simply to perhaps convince you not to come after them. But it doesn't hold up if it's an exculpatory clause and the court says that's not proper. Okay, if you can, the court can get rid of certain provisions that are illegal and the rest of it is valid, is okay, then they will do that. And we'll talk about, again, down the road, we'll talk a little bit about sometimes if someone's convinced to enter into a illegal contract and didn't know it, then we may protect them rather than just throw the whole thing out. Okay, so let's kind of review some types of contracts. The original contract we look at, I will trim your trees and I will pay you $100, is what we call bilateral, and that simply means there's two parties. So one party is contracting with another party. The offer is made and the acceptance is right there to a specific person. Unilateral contract would be the offerer says, I will pay to the first person who does that. Okay, so I'm not contracting with, making an offer to a specific person, but I'm making an offer to everyone, okay? And only one can accept. So that would be the reward. I'll pay $100 to whoever brings my dog back. Only one person can do that, okay? Okay, so we talked a little bit about express and implied. So express terms are that we actually state. Implies terms are either indicated by conduct or the law says that the terms are there. So express terms obviously give us more definite, but sometimes the court will imply in order to ensure fairness. And then the last thing we really talked about was the difference between void, voidable, valid. Okay, so a valid contract is a legal contract. It covers all of the requirements that we've talked about, and so it's valid and enforceable. They mean the same thing. You remember, a voidable contract is a contract one party can get out of, okay, and maybe it's only one side can get out of. And finally, void is one that has no legal force or effect, so it's illegal. Okay. So that's kind of been our introduction to contracts. We're going to be getting deeper into how we know whether people have performed, what the remedies are, and all that sort of thing next time around. I would like you to look at the Laulima site. There's a lot of information there that will expand on some of the areas that we just touched on. Okay, so this has Ben Carroll saying happy contracting. I will see you next time. Aloha.